Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar to learn more about special posting requirements for today's workforce. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and we will try to answer as many questions as we can about the material presented via follow-up emails after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 20 years, representing employers in a variety of matters, from discrimination and harassment litigation to defending FLSA class action lawsuits. Here at PosterGuard, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. As a special offer to our attendees today, Ashley will be available to set up a complimentary personal consultation about your specific posting compliance needs. If you are interested, please indicate that in the question box, and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome, everyone. Today we're going to talk about an area that often gets overlooked in employment law, and that is labor law posting compliance. All of the mandatory posters that employers have to post in the workplace. And more specifically, we're going to talk about some recent legal developments and trends that might affect your company's labor law posting obligations. For example, you may have unique posting needs if you employ remote or off-site workers. You may have unique posting needs if you're a federal contractor, if you have employees who don't speak English, if you have locations in certain cities or counties, and there are even special employee posting requirements for certain industries. So in other words, it's not just about your basic federal and state posters anymore. You might have additional posting obligations beyond your basic federal and state requirements that maybe you never had to worry about before. And posting compliance is really always evolving, especially lately over the past few years. So it's a good idea to step back and just take a look at what you're doing just to make sure you're completely covered and taking all the steps necessary to stay in 100% compliance. So let's get started by first reviewing some of the basics of labor law posting compliance. Posting compliance can be really complicated, and it's actually become more complex over the years as more and more laws are passed at a state and local level, giving employees protection in employment, especially over the past year or two. As most of you probably know, all businesses with at least one employee, all businesses have to post both federal and state employee notices. And if your city or county has posting requirements, you have to post those too, in addition to your federal and state notices. There are currently 6 mandatory federal posters, and they're listed here on this slide. First, there's the posting issued by the EEOC, the Equal Employment Opportunity Commission, and this one covers anti-discrimination provisions and protected characteristics under federal law. Next is the OSHA posting, and this one highlights important provisions of the Occupational Safety and Health Act. Next on the list is the FMLA posting, the Family and Medical Leave Act notice, and this gives employees basic information about their eligibility for FMLA leave, what benefits they can expect, and also your responsibilities as the employer regarding FMLA leave procedures, time off, reinstatement, benefits, and so forth. Next we have the USERRA posting, and USERRA stands for the Uniformed Services Employment and Reemployment Rights Act. This one covers reemployment after military leave, anti-discrimination provisions, and other issues around health care, health insurance, etc. Then we have the FLSA posting, the Fair Labor Standards Act poster, and this one notifies employees about the federal minimum wage rate, overtime rules, and also child labor laws. And then finally there is the EPPA, which stands for the Employee Polygraph Protection Act. And this one lets employees know the rules around lie detector tests in employment, polygraphs. And this posting is mandatory, of course, even if you don't use lie detector tests. It's a question I get a lot, so I wanted to go ahead and mention that up front. It is mandatory even if you don't do polygraphs. Okay, so those are the federal posting requirements. And then on a state level, there are additional mandatory postings that are required for every business. Depending on what state you're in, this can add up to 15 additional posters. So that's up to 21 total federal and state posters, depending on your location and what state you operate in. And this area of compliance, like I said, on a state level, is becoming more complex and difficult to manage over the years because we're seeing more and more laws being passed on a state level that give employees protection in the workplace. And whenever a new law is passed, there's a potential poster update. Either there was a law already in place and the new law has expanded the rights so the poster needs to be updated, or in a lot of cases we're seeing brand new posters being issued. We're seeing states issue laws where they never had a law before, and a brand new poster is being released and that becomes mandatory. The state posters typically cover topics like minimum wage, the state minimum wage rates, state fair employment laws, unemployment insurance, workers' comp, rules around smoking in the workplace, paid sick leave, child labor, and then some newer areas we're seeing like human trafficking, expanded family care rights and small necessity leave rights, and also electronic cigarettes in the workplace. That's federal and state. On top of this, as I mentioned, you might have additional posting obligations if you're in certain cities or counties with their own posting requirements. And this is an area where we've really seen a lot of growth over the past couple of years. I'm going to show a list of the major cities and counties with their own requirements as we get into the presentation. But at this point, I've seen up to 9 additional postings in a single city. So that can really add up. So as you can see, there's a lot to keep up with to stay in compliance. And if you're in certain industries or if you have government contracts, there are even more mandatory posting requirements that apply to you. I'm also going to get into that a little bit as we get further into the presentation. So another thing that a lot of people aren't so familiar with is that there's not a one-stop shop for free government posters. And this just adds to the complexity of posting compliance today. There's not a central place or a website where you can get all the posters you need from a government agency. There's actually, across the country, there are about 175 different agencies that are responsible for issuing the posters. And that's just on a federal and state level. Not talking about the industry specific or the federal contractor or the city and county postings. And just, again, talking about the federal and state postings, there are about 370 different mandatory posters nationwide. And like I said, each posting is enforced and regulated by different agencies. So in any given state, just to manage posting compliance in one single state, an employer would have to go to up to 9 different agencies to get the required posters for federal and state law. And then on top of that, there are also about 22,000 cities and counties, each with their own governing agencies and ordinances that also have authority to issue posting requirements and issue mandatory postings. Luckily, not all of them have mandatory posting requirements, but a lot of them do, and like I said, we're seeing this number grow every day on a local level. And none of these agencies, whether it's federal, state, or local, these agencies don't have work share agreements where one agency provides all the posters that a sister agency requires. In some cases, there are some agencies that do try to help out and do a pretty good job where you can see some crossover where, for example, one agency might have posters that are governed or enforced by another agency within that same state. It's not a complete list. And you're certainly not going to see crossover between the federal and the state posters, and certainly not the city-county postings. The local agencies on a city-county level really act independently. They operate on their own apart from the state and federal agencies. So, each agency has to be contacted and monitored in order to get the correct postings and stay on top of them. Adding to this complexity is the fact that posting changes are also on the rise. So one of my roles with HR Direct is to oversee the legal research team that researches and monitors all of the posting laws for Poster Guard customers. And on average, our legal team sees about 150 state law posting changes every year. And by the way, I'm going to be mentioning Poster Guard, and if you're not a Poster Guard member, Poster Guard is a service that helps employers comply with all of these posting requirements that I'm talking about today. So you'll hear me mention it a couple times. But anyway, every time there is a posting change or a new poster that's been released, the Poster Guard in-house legal team reviews the poster and the underlying laws to determine if the poster is mandatory or the poster update, whether it's mandatory or non-mandatory. And at least half of the state law changes that come through are mandatory. They do require a mandatory update or an immediate replacement of the posters or immediate compliance by posting a new poster. So about half of the changes we see, so that's about 75 typically state changes that we see that are mandatory a year. And on a local level, city, county level, sometimes we get 2 or 3 mandatory changes a week. It really just depends. We do see more changes near the end of the year and also in the summer when a lot of states and cities raise their minimum wages, but poster changes happen all year long. And year over year, we've seen the number of mandatory changes increase. In fact, this has already been a record year. I mentioned we typically see about 75 mandatory changes in a year. This year, we've seen about 70 mandatory changes just in a 4-month period. So the rate of change is definitely increasing. And we expect that number to continue to rise as more and more states and local governments are stepping up right now to pass their own employment laws. And that's, really also in relation to the federal government and what's going on at a federal level. Either when there's a standstill or a deadlock on a federal level, or when there's an initiative toward deregulation on a federal level, we see states and cities stepping up and passing their own laws, and that's a trend we expect to continue with the new administration. So all the action really right now is on the state and local level. Another problem adding to the complexity of posting compliance is that the government agencies don't notify employers when these posting changes occur. So this can be really difficult because you have to actively monitor the posters and the underlying employment laws for changes. And it's not always obvious when there are changes. It's really not that easy. The posting requirements and the poster changes, the poster change notices, sometimes are buried on different agency website pages. A lot of times you'll go back to the site or the web page where you've gotten your posters before, but the old posters will remain up and active with no notes or indication that they're no longer compliant, no redirection to the new poster. But then when you research around and fish around, you'll find that there is a completely separate page with the current poster and that it was a mandatory change and that the old one is no longer compliant. So sometimes that can be buried on web pages. You can also find a lot of posting laws and posting content can be in employment statutes or even regulations, or in some cases even in court cases and case law. So it can be difficult to find the mandatory posters and even more difficult to track all of the changes. And then on top of that, to interpret whether the updates are mandatory with compliance deadlines or just cosmetic changes you can ignore. There's a lot of interpretation, too, with size, font, color requirements. Are there foreign language requirements? What is the deadline for posting? It's not always the same as the compliance date for the law. That's reflected in the poster. And those are the things that we handle for our Poster Guard members. The legal research team does all of that research and analysis for each poster change and communicates that to Poster Guard members. Okay, so I included this slide because there's still a lot of confusion about the risks associated with labor law posting compliance. And also because there have been some recent changes to the penalty structure that are pretty important. So I wanted to cover that really quick. So I get a lot of questions on this, and I hear 2 things a lot. The first is that government posting fines are so small that it doesn't really matter if we get caught. And the second is, well, there are no poster police out there, so how would I ever get caught anyway? So I'm going to address both of these misconceptions. First, when it comes to the amount of the fines, the penalty amounts are actually pretty significant, and they can certainly add up if you have the same types of violations at multiple locations. Usually when you're doing something wrong, that's occurring at all of your locations, so these can really add up. In terms of federal posting fines, the government is now authorized by statute to fine employers up to $33,000, actually it's a little more than that, per location for posting violations. It actually was just increased to $33,486 per violation. And that's based on the most recent increases that just went into effect this year in January. And again, that's per location. Government fines can be issued for missing posters, just missing a poster altogether, or for outdated posters, for having an old poster up that had a mandatory update. The increase that I mentioned that went into effect in January was part of the Civil Penalties Inflation Adjustment Act, and that first went into effect in 2016, and it calls for increases on an annual basis in line with inflation. So before that, though, the fines were only $17,000 per violation. So they added up to $17,000. So that's a pretty significant increase. It almost doubled in just the past 2 years. And then again, the Civil Penalties Inflation Act calls for increases going forward every year to keep in line with the inflation rate. So the fines are expected to gradually increase going forward each year from here. So that's for federal postings. On a state and local level, the government posting fines are typically in the range of somewhere between $100 and $1,000 per violation. Again, each posting has its own underlying laws and its own fines attached to it, so it's really all over the place. There's actually a California poster, I think, that carries a fine of $7,000. But otherwise, this range here is pretty accurate. It's typically under $1,000. In my experience, at the local fines that I've seen are typically in the range of about $500 up to $750 per violation. So the second misconception that I mentioned is that there are no poster police out there, so there's no need to worry about government posting fines. So the reality is the government rarely sends out representatives on a federal level just to enforce posting laws. That's true. We have seen this, however, on a state and local level, where there have been poster sweeps by either the enforcing agency or even the state attorney general. But on a federal level, government posting fines typically are assessed because the agency's on your premises for another reason. They're not just out there to get you for posters. It could be an immigration-related issue. It could be an OSHA inspection, an EEOC on-site investigation. Or even, most commonly, it could be from a Department of Labor audit. And, the DOL, those audits or investigations are triggered, just by a single employee complaint. It could be a current employee, a former disgruntled employee, whatever it is, and they come out for something having nothing to do with the posters. It could be unpaid wages or an overtime violation, a meal break issue, so it's unrelated to the posters, but the agencies always check posting compliance as part of any on-site visit. It's actually part of the field operations handbook for the investigator or officer to check your posting compliance. But the real danger with posting violations is actually related to employee lawsuits and employee disputes. It's not just about government posting fines. And there are a few different ways that posting compliance comes into play with employee lawsuits. The first, and I think the most significant, is when it comes to the statute of limitations. In my experience defending businesses in employment litigation, I like to refer to the statute of limitations as an employer's best friend in litigation because it's the defense that allows you to have a claim stricken or entirely dismissed just because it was filed too late. So the statute of limitations, for example, in a federal discrimination claim is 300 days. It's different based on state law, but under federal law, it's only 300 days. For example, for the Fair Labor Standards Act, for overtime or misclassification or unpaid minimum wage, the statute of limitations is 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation that occurred outside of that time period, you can move to have that claim dismissed and avoid all the legal fees and potential liability for the claims in the lawsuit. Even if a violation occurred, you can escape liability just based on the timing. You can also use the statute of limitations to cut off damages for violations that occurred before that time period. If it's a repeat violation or a class action that involves more than one violation or more than one plaintiff. So it's really an important defense in almost every case, especially if you have multiple plaintiffs or a repeat violation. The problem is if you have a posting violation, either you didn't display the current poster or you're missing a poster, courts have begun to publish more and more decisions saying that if an employee didn't have notice of his or her rights, the statute of limitations is extended or tolled, and you cannot use it as a defense. So this is pretty serious. We've seen cases where normally an old claim could have been dismissed, where the court allowed the plaintiff to pursue the claim, and it ended up in a six-figure judgment just because the posters were not up on the wall. And then another way that posting compliance comes into play is as evidence of bad faith in an employment, in a related employment lawsuit. Whether it's Fair Labor Standards Act or a discrimination case or an ADA case under the Americans with Disabilities Act, each law is a little different. But under the various laws, under federal and state employment laws, there are different legal standards and names for it. But if there's a finding of bad faith or in some cases a lack of good faith, this can directly affect your damages. It can either inflate your damages where there's bad faith or a lack of good faith, or it can stand in the way of a good faith defense that would have otherwise reduced or eliminated your damages. And on this area, we're also seeing a lot more court cases where posting compliance is one of the factors courts are looking at when assessing these kinds of damages relating to good faith or bad faith. They look at a variety of things. Did you have a handbook in place? Did you train your employees? Was there management training on, compliance issues? How do you respond to compliance violations and allegations, but also posting compliance? By the way, we have a white paper with all the case law on this, examples of cases with everything I've just been talking about with this slide. So if you'd like a copy, just indicate that using the chat feature, and we'll be happy to email that to you after the presentation. And then finally, one more point here. Under the FMLA, the Family and Medical Leave Act, you can actually be faced with a civil lawsuit just for not having the poster up or having the wrong version of the poster up if the failure to post the proper notice ended up interfering with someone's FMLA rights. So these are pretty severe consequences that everyone needs to be aware of, and these are very good reasons not to take posting compliance lightly. Okay, so that's a brief overview of today's posting compliance environment, just the basics. But today I wanted to focus on some additional requirements that are newer and that have evolved that might apply to your business to make sure you're completely covered and staying in compliance. So here's a list of the topics that we're going to go into in a little more detail. City, county, the local posting trends, foreign language posting requirements, electronic postings, obligations for your remote workers and telecommuters, as well as non-traditional work sites without walls, industry-specific and federal contractor posting requirements, applicant area posting obligations, including online applicant tracking sites, and no weapons postings. Okay, so let's get started with the city and local posting requirements. And like I said, this is a fairly new trend that has really taken off over the past couple of years. There are actually a lot of cities and counties that are now requiring employers to post these mandatory employee notices, mandatory labor law posters, in addition to all the federal and state notices that we've been talking about. On this slide, we've listed some of the bigger cities and counties that have popped up over the last couple of years, and then also some of the more recent the more recent ordinances that have popped up. So this is not a complete list, but these are the major ones and the most recent ones. And in some of these cities, there are multiple posters that are required. In San Francisco, for example, I think there are now 9 mandatory city posters on top of the federal and state. So I think that adds up to about 30 posters, fed, state, and city, if you operate in San Francisco. Philadelphia also has a lot. I think they have 7 mandatory posters now. But for the most part, when you see these cities listed, it's just 1 or 2 posters. But you also have to remember a lot of these have mandatory foreign language requirements. On a city level, a lot of posters have to be posted in multiple languages, even if all your employees speak English. So that can really add up as well. Again, this is not a complete list, just some of the major cities and also ones with recent changes. And like I said, this list is quickly growing. Our legal team here at Poster Guard is monitoring and tracking all of the local posting requirements across the U.S. We've actually expanded to cover every city and county. So like I said, almost daily, 2 or 3 times a week, we're analyzing new legislation that is coming out that does require mandatory posters. And sometimes more in the summer months and toward the end of the year. We've had weeks where we've seen 5 or 6 changes in 1 week. Another question I get a lot, I just wanted to cover here, is whether you have to hang all of the posters, federal, state, and city, if the information on the posters conflicts or is different. So, for example, if you have 3 different minimum wage rates, 1 under federal, 1 under state law, and 1 under local law, do you still have to post all 3 versions of the posters? And the short answer is yes. So, even though you have 3 different posters with 3 different minimum wage rates, that is the law. You have to display all 3 posters. Now, when it comes to which law to follow, of course, you follow the law that is the most generous to the employees, which would be the highest minimum wage rate, or if it's a paid leave posting, you follow the law with the longest period of time off for your employees. But you still have to hang all the posters even though they conflict. Okay, let's move into foreign language posting requirements. There are actually 22 states right now and Washington, D.C. that require employers to post certain postings in Spanish. So where you're required to post in both English and Spanish, regardless of your workforce demographics. So that means even if you don't have any Spanish-speaking employees at your work site or at your location, and all of your employees speak English and are proficient in English, these 22 states still require that you post certain posters in Spanish. In these states, it actually adds up to, I think, 47 individual postings that have to be posted in Spanish no matter what. A few states go even further and have requirements in other languages. It's usually Spanish, but we've seen up to 11 different languages, Russian, Japanese, Arabic, Mandarin, Creole. And then a lot of cities and counties, like I mentioned, also require you to post in multiple languages. In some cases, on a city and state level, in some cases, the multiple language versions are required for everyone, no matter what. And in other cases, it depends on whether you have a certain percentage of the workforce who speak that language. And then just as a side note before we move on, in Puerto Rico, all of your postings have to be displayed in Spanish, and then English is just a best practice. Okay, so this is the list of the 22 states that currently require certain postings to be displayed in Spanish. Like I said, even if you don't have any Spanish-speaking employees. And just to be clear, because this is confusing, I always get a lot of questions about this. I'm not saying in these states that all of your posters have to be in English and Spanish. It's not all of the state posters. It's just certain ones in these states. Also, I've included this list just to make sure that if you operate in these states, that you have at least one posting requirement that is bilingual. So in some of these cases, it's just one of the posters that have to be in English and Spanish. In other states, it could be 3 or 4 of the posters that have to be. And one thing about Poster Guard, by the way, is that we automatically include any foreign language poster with your basic English service if it's a poster that's required for all employers. So if it's something that you have to post no matter what, even if all your employees speak English, this is automatically included with your regular English service. And so you don't have to research it or ask for it. If it's required, it will be included to make sure you're in compliance. Okay, if you do have locations with Spanish-speaking employees, then there are some additional Spanish posting requirements that you need to know about. So things change a little bit when it comes to these locations that if you have a significant number of Spanish-speaking employees. So first of all, when it comes to the federal postings, these are the different legal standards. When it comes to the federal postings, if you have a significant number of Spanish-speaking employees who are not proficient in English, you need to post the federal combination poster in both English and Spanish. And that's because of the FMLA. It's required by law for the FMLA posting to post in both languages based on this legal standard. Then on a state level, there isn't a requirement that's written into law that says you have to post every poster in both English and Spanish, even if you employ a significant number of Spanish-speaking employees who are not proficient in English. However, while it's not required by law, most employers who have to post the bilingual federal poster, because they do have a significant number of Spanish-speaking employees, in that case, most employers choose to go ahead and post all of the state postings in both languages as well. And again, that's just because it's a best practice. It's not mandatory. It's just a best practice. It would be hard to explain in any kind of dispute why there was a choice made that certain posters were posted in Spanish because we know that our employees are not proficient in English, but then we didn't take the extra step to post all of the mandatory notices in the languages that we knew our employees would understand. So it's a recommendation, best practice. So there is one exception, and that is in Pennsylvania. In Pennsylvania, employers who employ Spanish-speaking employees do have to post all of the Pennsylvania state posters in English and Spanish. Unfortunately, the agency doesn't provide a really clear definition of who this applies to. It doesn't say significant number or, there's no clarification there. It simply says that it applies to all employers with Spanish-speaking employees in Pennsylvania. So to be safe, if you have Spanish-speaking employees in Pennsylvania locations, you should be posting all of the Pennsylvania posters in both English and Spanish. Okay, now we're going to move on and talk a little bit about electronic postings. And this is something that we watch really closely for years. Our legal team has been in contact with the government agencies, and we're constantly reading all of the agency announcements and posting guidelines as they come out. But unfortunately, the government agencies, when it comes to posting compliance, haven't really caught up with the modern technology of today's workforce. So the general rule is still that electronic delivery is not a substitute for the full-size physical posters on the walls. Your posters still have to be posted in conspicuous locations. This is the standard. They have to be posted in conspicuous locations accessible to all employees in physical format and posted on your walls throughout your facilities. There are a couple of exceptions, and these are some of the more recent developments. As new regulations come out, as new posters come out, we are seeing the government agencies address this. We've seen it with the most recent FMLA regulations, and then also when the USERRA notice first became a requirement. It also is, we've seen it in place with a couple of the federal contractor posters that I'm going to talk about. And in with these limited exceptions, the government agencies have said it is okay to communicate these particular posters electronically, but only if you communicate all your other employee policies electronically, and you have to make sure that all of your employees have electronic access and are receiving the posters electronically. So that can be really difficult to stay on top of for a lot of workplaces. It depends if you provide your employees with electronic access. You have to know that they either have a computer that they work with or a mobile device or some way of accessing the posters, and that they use computers and have access to email or internet as part of their jobs. if you're going to rely on the electronic versions. It's also tough because only a couple of the posters can be communicated electronically, and all the others, we talked about up to 21 federal and state posters per state and city-county posters. All the other posters still have to be posted on the walls. So it's really tough. It really doesn't make sense for a lot of businesses to worry about two different implementations, to have a couple of posters on a company intranet site, but all the other ones up on the wall. It gets difficult with, in terms of consistency. So most employers just rely on the wall posters for everything, even though a few of the posters could be communicated electronically. But next, we're going to talk about some special rules, actually some exceptions when it comes to telecommuters or people who work from home or off-site and they work with computers, and also for non-traditional work sites that don't have walls. First, let's talk about remote workers and telecommuters. So, for years, the Poster Guard team, the legal team, has gotten questions from customers saying they have employees who work from home and they want to know what they're supposed to do in terms of the posters. They want to know, should they be sending their home-based employees the full-size laminated posters? And we've all kind of laughed just trying to imagine someone working from home and putting up all these posters, because they do take up room and there are a lot of posters. We, trying to imagine them on someone's refrigerator or bathroom wall or in their kitchen at home. And obviously that wouldn't work for everyone, and that is not required. But it is kind of confusing because by law, you are required to provide the information. You are required to provide the mandatory notices to all employees. However, the regulations don't tell us exactly how that's supposed to be done or how that has to be done when it comes to your off-site employees. They do tell us that you're required to communicate the information, but they don't tell you that you have to use a certain solution or format, or whether it has to be paper or electronic. But there are some court cases where employers have sent notices electronically to their off-site employees, and the courts have said, yes, that is a good alternative, that makes sense. You got the notices to them, and that's what counts, so that is compliant. And also the federal agencies, the DOL, the Department of Labor, and the EEOC have also more recently indicated that it is one way to comply for your off-site workers, electronic communication. Particularly, one of the questions that the DOL answered had to do with employees who come in to the office less frequently than 3 to 4 times a month, and whether electronic posting or some other solution would be required to get them the posters. And the DOL did say that yes, for these workers, you do need to provide the content of the postings as a supplement to the wall postings that they might see in the office. And in fact, the DOL specifically refers to electronic posting as an acceptable format, recommending electronic postings for these employees who come in less frequently than 3 to 4 times a month. So an electronic solution is definitely the best way to meet this obligation for your remote workers, rather than if they work on computers, rather than sending the full-size laminated posters. As a best practice, and if you're implementing an electronic solution to get the postings out to your off-site employees, I would recommend looking for a solution that pushes out alerts to these employees so they're constantly updated when the posters change, since the postings do change frequently throughout the year. And also, ideally, to have a solution that tracks the employees' acknowledgments. So you have proof that the employees were provided access to the latest postings and that they did indeed view them. You can do it other ways. You could place links on your company intranet site, for example, but the key is to make sure the postings are complete and always up to date, keeping up with the changes, and that your employees have notice, that you've built the awareness of where to get the posters, that they have access to the postings, and that they have notice when the posters change. And then, of course, that you've just made sure in as many ways as you can that the employees are aware that the posters exist and how they can access them, and that they have easy access to the posters. Okay, next we're going to talk about what we call non-traditional work sites, work sites without walls. And this is something that's really, we've seen kind of take off more and more in recent years. just a new way of employing workers, and something that we've seen a lot of customer demand for. And there are really a lot of workstations and work sites today that don't have walls or any way to hang up the required postings. And the employees don't necessarily have computers. They're not necessarily provided with computers or electronic access for their jobs. So some good examples are mall kiosks, the little kiosks that you see in the middle of the mall. The employees don't necessarily have internet access or any kind of mobile device that's provided, but they also don't have walls. Other good examples of these kinds of work sites are valet stations, construction checkpoints, food trucks, and also other kinds of mobile service units, which we're seeing a lot of today, especially in healthcare. There are a growing number of mobile services like MRI units, mammogram on wheels, kidney dialysis services on wheels, or even blood donation trailers. We've also seen this with businesses who perform services on another company's property, where maybe you have contract employees who perform work on a third party's property. Also, for example, like with janitorial services, where maybe there's just a checkpoint where employees go to get their supplies. It could even be a closet or a storage area, but there are no walls. So for these kinds of work sites, I would first consider if there's any way to communicate the posting to each person electronically, like the solution we just went over. But if the employees are not working with computers or mobile devices, or they're not provided with internet access as part of their jobs, you need to consider other alternatives. One that I recommend is a binder option, where all the required postings are kept in a compact binder format, something that could either be hung on a hook or placed on a desk. You want it to be visible. You also just need to make sure that these are updated whenever there are mandatory changes, and again, that you make them accessible and as visible as possible to your employees. Make sure they know about the binders, make sure they know where they're kept, that the binders are accessible at all times. And just to reiterate, this is important, these binders cannot be used as a substitute for the regular wall postings if your facility has walls. We would all like to see that, because I know these take up a lot of room on the walls, but the Department of Labor has been very clear about that. These cannot be used as a substitute in an environment that has walls. But they are compliant for these non-traditional settings without any walls at all to hang posters up. Okay, now I'm going to talk just a little bit about industry-specific posting obligations. There are a lot of industries that have additional posting requirements beyond the regular federal and state postings that all businesses have to display. The ones that have the most, and I'm just talking right now about employee-facing notices, not the kinds of posters that you need for your customers or for patients or for guests, just talking about labor law postings, employee-facing posters. There are actually several additional posters required for public sector employers, employers that are in the healthcare industry, and employers in the restaurant industry or any kind of food establishment. For the public sector, which are typically government agencies, the requirements are very different from the private sector. There are different versions of the federal posters, and then there are a lot of additional state and local posters that don't apply to private companies. For healthcare, in addition to all the mandatory postings we've been talking about for general industry employers, if you're in healthcare, you might have up to 15 additional employee-facing notices to display. And it really depends on your state and what type of facility you operate, what kind of equipment you have in the facility as well. So typical examples of these kinds of posters are radiation notices. There are employee notices on how to treat patients. There are special overtime rules for employees in healthcare. And there might be special ethics and complaint procedures that are employee-facing depending on your state. For restaurants and food establishments, there are also a number of additional employee-facing posters required, and that also depends on your state. Some examples are choking posters, notices for tipped employees, CPR procedures, information about serving alcohol to minors, And believe it or not, the posters on how to wash your hands vary from state to state. And some have mandatory versions in terms of the language and the appearance of the posters, the graphics and the actual verbiage on the posters. So I don't want to spend too much time on these industry-specific posters because I know they don't apply to everyone, but it is important for you to know they are out there, that they do exist. And, of course, feel free to ask for more information in the using the chat or the question box. If you have a specific question about the industry-specific requirements for your state, really, or any of the other posters that I'm going over, and we'll be sure to follow up with you if we can answer your question, since I'm not going to have time to cover every state and for these industries. Okay, now we're going to talk about federal contractor posting requirements, and this is not really an industry-specific issue because there are so many different types of businesses that may be covered by federal contractor posting requirements. In recent years, really the past 5 to 10 years, we have really seen the number of businesses grow that are covered by these federal contractor requirements. And that's just because of developments in the economy and new government funding initiatives that really apply to more types of businesses. Also, we've seen a lot more executive orders with laws for federal contractors and a lot of new posters resulting from that. It used to be something, when we talk about what types of businesses were covered by these requirements, it used to be something we talk about mostly for construction or defense contractors. But in recent years, we've seen it expand to more and more to finance and banking, telecommunications, technology companies, educational institutions, transportation, and even a lot of nonprofit organizations. And like I said, we've also seen a lot more posters being required for federal contractors. And that's really a direct result of all the executive orders that have been issued to protect and expand the rights of employees working on federal contracts. So as a federal contractor, the specific posting obligations that you have typically depend on what kinds of contracts you have and with what government agencies. And then in some cases, it also depends on the value of the contracts or the amount of funding received under those contracts. So this is a list of the most common postings that are required for federal contractors. I believe it's up to 14 postings now. I'm not going to get into all the specifics for each one of these, but we also have a great white paper on this that goes through all of these posting requirements and who they apply to help you determine if you need, which of these might apply to your business. So if you'd like more details on, what these are and whether they apply to your business, just indicate that in the question box, and we'll be happy to forward you a white paper on this to help you understand these laws and these posters. A lot of these posters are required for all federal contractors, and then some of them, like I said, will just depend on your specific contracts and activities. So that's what the white paper covers. So as you can see from the notes on this slide, these posters change frequently, and that includes, updates and also new posters being created. And then there are also some posters that will be changing on a yearly basis, like the minimum wage rate. So they have recurring changes. And this slide, I also went ahead and highlighted some of the more recent mandatory updates just to make sure everyone's aware and that you have the most recent versions of these posters. So these posters change a lot more frequently than the regular federal posters, and they also seem to have less lead time. A lot of these just kind of pop up as a result of an executive order without much notice. Certainly not as much notice as we see with the regular state and federal posters that typically go through a more lengthy legislative process before a law is passed and before it becomes a posting requirement. These sometimes just pop up with not much notice at all. Also, the penalties for noncompliance when we talk about these Fed contractor posters can be even worse than what we discussed for the regular federal and state posters. If an employer doesn't comply with the federal contractor posting requirements, there are not only steep fines, but you can also lose your government contract or funding. It's typically written right into the contract that the contract can be suspended or canceled just because of noncompliance with these posting requirements. Okay, next we're going to touch on applicant area postings. And this is an area of compliance that a lot of people are just not that familiar with, and it's really important because with an officer or an auditor or some kind of inspector that comes in, they really don't have to go that far to see if you're in compliance. And a lot of employers don't realize this, but out of the 6 mandatory federal postings that we went over at the beginning, 4 of those posters have to be displayed in an area where applicants can view them. And the posters that are required for applicants are the EEOC posting, FMLA, USERRA, and EPPA. Just a little note here, don't forget that the EPPA posting did have a mandatory update at the end of the year of the end of 2016. So you just need to make sure that you have the current version up for your employees as well as your applicant areas. So you have a few different options for complying with applicant area posting requirements. If you allow applicants to walk in and take an application or apply in person, you need to display the postings where they can view them. So if you provide a small work area for applicants, like a desk or a kiosk, you can use a compact format with all the applicant postings on a small sheet. And it can be pretty small to save on wall space because these particular posters don't have a minimum font size requirement spelled out in the law, as long as the font size is reasonable, of course. These can be shrunk a little. That's not true of all posters, but with these 4, that is the case. So if you have a dedicated area for applicants, like a room where you do interviews or conduct pre-employment testing, then I would recommend going with the full-size posting display, one that's not necessarily condensed down. And there's a larger format with all the required postings in a full-size poster. If you accept applications online, electronically, you need to provide a link so the applicants can view the images electronically. That is required. So in most cases, employers end up needing a combination of the electronic postings for their online applicants and a physical wall display, or, the physical posters on the wall for any kind of pre-employment interviews or other meetings that you might have in person with job candidates. So I get a lot of questions on this. I want to make sure I've covered this adequately. I know it can be confusing. If you only accept applicants online, then the electronic version would be all that you need. However, this is, rarely the case because, if you allow applicants to come into your facility for any reason, like if you accept walk-ins or if you do any kind of pre-employment screening or interviews at your facility, then you would also need to have the posters displayed physically where they can view them when they come onto the premises. Okay, and then finally, another trend that has emerged fairly recently, and it's getting a lot more attention based on recent events, is the regulation of guns and weapons in the workplace. And, of course, the corresponding postings or signage that businesses need to display to communicate their policies on weapons in the workplace. So when it comes to these postings, these aren't really considered mandatory postings for all employers, but they are required in a lot of states if you wish to prohibit employees and guests from bringing weapons onto your property. So a lot of these postings are only mandatory if you have an anti-weapons policy. And then you have to follow the law on what to post and how to post it. So there are now more than 20 states that have enacted some type of legislation addressing guns in the workplace. And typically, these laws are actually designed to protect employees or and individuals' right to possess firearms. And they vary from state to state in terms of their restrictions. And that can really make it tough for employers. If you operate in multiple states, you can't necessarily just take a no weapons allowed sign and post it on your doors. You have to comply with the different state law requirements. One generic approach doesn't always work under these different state laws. There's research involved in getting it right. In some cases, that will work. A generic sign will work. But in other states, there are specific laws on what you have to say, how you have to say it, and in some cases, even colors and graphics and everything else. In some cases, the state laws are actually strict about the language on the postings. Like I said, there can even be size, font, and color requirements. Again, in other states, generic no weapons postings are fine. Tennessee is just an example. In Tennessee, employers who want to prohibit guns in the workplace have to post a sign that specifically says no firearms allowed, and it has to include a graphic red circle gun ban symbol on it. Texas has specific requirements too. I've tried to show some images here on the slide. Based on a 2016 state law amendment, employers in Texas who want to prohibit concealed and open carry weapons now have to post two different postings, and they have to be in both English and Spanish. So when it comes to these no weapons postings, I just wanted to provide an overview just for awareness when it comes to these laws to make sure that you know they exist. But obviously, I'm not going to have a chance today to go through every single requirement state by state. So again, I invite you to reach out to us if you have a specific question on your state and what kind of no weapon sign you would need to post, or with anything else that I've mentioned today. We'd be happy to follow up with you and share that information to help you get into full posting compliance. Okay, well that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of legal requirements and details, but there's a lot to share when it comes to these laws and your obligations when it comes to posting compliance. If you have any questions or would like additional information about poster guard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfray, P-F-R-A-Y, at hrdirect.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.